Well, welcome everyone. We're going to get started in a few minutes with our next session, Global Update on Privacy Laws, Regulatory Considerations, and Oversight. So I have the pleasure of introducing our moderator, Alex White. He's the Privacy Commissioner for Bermuda. Commissioner White has served as Bermuda's first Privacy Commissioner since January 2020. And he is a member of the Global Privacy Assembly Executive Committee since January 2022. Mr. White is a lawyer, qualified to practice law in the United States, and a former U.S. Federal Privacy Advisor, an IAPP Advisory Board member, with experience working in the insurance industry and managing a state government's privacy program. Alex, it's my pleasure to welcome you.
Thank you very much. And with apologies to the panelists, I don't have the bios in front of us. So as we go through our first question, let's each of you take an opportunity and talk about yourself for just a moment to help people understand what perspective you're coming from. But thank you. We're here today to talk about privacy laws, regulation, and oversight. And as we talked about in our planning conversations and just now, this is a topic that we could go all day, but don't worry, I'm watching the clock, so we won't go all day. But we're not going to be able to cover everything. And so what we hope is to give you kind of a taster menu of these issues and something you can take back and do some research on for yourself. Generally speaking, when we talk about privacy laws and regulations, we're focusing on a law that's creating a specific right for an individual about the personal information that relates to them, and also describing practices that organizations have to undertake, such as implementing a risk management evaluation program, implementing security controls, or mandating data breach notifications, to give a few examples. The word oversight can cover a lot of ground. It means more than the actions of just regulators, I say as a humble regulator. It can happen through courts, economic markets, self-regulatory schemes, and citizen action. In Bermuda, our office is the Data Protection Authority, and we have a philosophy of constructive oversight. Our thinking is that no party should hold a confrontational cat and mouse mindset, but should seek proactive and constructive engagement. And that's the only way that we'll be able to successfully protect these rights, is if we're all working together in this idea of it taking a village. But that said, I can't simply ask organizations to trust us and bring us into the process without giving trust back. And so that should be an important component of oversight as well. Not only making sure that certain standards are met, but also recognizing the positive contributions that organizations are making and crediting for their hard work and good faith. So that's my soapbox, and now I just get to pitch questions from here. So very excited to do that. And our first question, and again, if you could each start out by just introducing yourself very briefly, but why do you see privacy as an important issue that we should be talking about today? Let's start with you, George, and go down the line.
Yeah, thank you, Alex. My name is George Chaisty. I am a partner at the law firm Kennedy's. As you can probably tell from the accent, I'm based in the UK, where I help lead the UK arm of the global cyber practice. And I personally specialise in breach response primarily, but also data subject litigation, data privacy advisory work as well. So to answer your question, thank you for that, Alex. Well, for me, data privacy is so ripe for discussions like this because the global privacy landscape is changing so frequently. I think even since the NetDiligence conference in Santa Monica just a few weeks ago, things have changed so much that the discussion we're about to have probably looks very different to the discussion just those few weeks ago. And I think for that reason, it remains a hot topic. And something that we'll be covering later in the session, I'm certain, is some of the enforcement action and increasing regulatory scrutiny, not just in the UK from my perspective, but globally, which really seems to be opening our client's eyes to the very real need for pre-breach compliance with global data privacy legislation. And as I say, for that reason, remains a hot topic.
Thank you. And Nicole?
Hi, Nicole Sterling. I'm an associate at Baker Hostetler in New York City. I'm part of our digital assets and data management practice group, and do most of my work within the privacy governance part of that practice, but also work with our incident response team on international data issues that are related to incidents that do occur. And in terms of why I think privacy remains important, I think within the US we're seeing a lot of movement forward on the privacy issues as a sort of reflection of what's happening globally. But I think it's been interesting too to track how since we saw initially with the GDPR, all these companies worried about fines, and now that individuals are becoming more interested in the topic and we're seeing actual sort of people out there interested in privacy, there is this sense around like brand reputation and trust in brands that I think is really interesting in the privacy landscape, that keeps driving it as a compliance point, that it's not all just about large fines now, that it's actually about you can lose money sort of commercially by losing the trust of the people in your company.
Great thread to pick up as we go. Thank you. Next, Karen.
Thanks, Alex. Good afternoon, everyone. Everyone looks really excited to be here to hear about the global and fast evolving landscape in privacy. But you really can't talk about privacy without talking about security. My name is Karen Randall. I'm a partner with Connell Foley, located in New Jersey, New York, and Philadelphia, and I chair our firm's cybersecurity incident response and privacy practice group. And we got into the space in 2008, and I cannot tell you how fast it has evolved since 2008. Some of you might have been there before 2008, but I always say to people who get into this space, if you're not reading and learning on a daily basis about privacy and security and the evolving landscape, on a daily basis, you're going to be behind by 2 weeks the next day. That's how fast it's evolving. And obviously, based upon the attacks that you've seen out there, privacy, security of information, the personally identifiable information, the medical information, the financial information, now the biometric information is a huge concern to the consumer and to enterprises who you will hear later are now being fined. Some are going to jail. Some are having criminal charges being brought against them, the leadership within the organization. I think there was a study that came out just recently where the consumers basically said, I think it was 70, 80% of the consumers said that their personal information, social security numbers, financial information, passport numbers, you name it, whatever's classified as PII under any of the statutes, state, federal, or otherwise, they think is very important to them, and it should be protected. So I'm looking forward to today's conversation. We've got great people as panelists. Thanks, Alex.
Thank you. Well, and so let's mix the order up. And so for this next question, let's do Nicole, George, and Karen. So how about this? So what do you see as the driving change what do you see as driving the change that we are seeing in the privacy landscape? And what do you think are the biggest challenges to watch regionally?
Yeah, so I'm going to pick up on 3 different sort of trends here. One is the sort of ongoing influence of the GDPR and the EU laws as we see that sort of roll out globally. But the fact that especially major jurisdictions are putting really interesting twists on that as well that are making it a bit more difficult to comply with. And then this sort of, because of that, you end up with this discussion of global versus local approaches, and what it's kind of like a risk versus efficiency kind of narrative there that I'll talk about in a second. And then also this idea of the value of data, and I think some of this is being driven by the move away from third-party cookies, and we'll get back to that too. So on the EU influences, it has been interesting because a lot of the sort of shape, I think, of what we're seeing as new laws after the GDPR are really kind of following those trends. But we are seeing some really interesting differences. I think in the US, we're seeing a lot of movement around kind of this consumer protection piece, but this targeted advertising piece that we see again and again in the US laws that isn't quite the same through line in the GDPR. And then also with financial data is another piece that is not a special category of data under the GDPR, but under many of the new laws that we're seeing is categorized as sensitive personal data, which is creating issues when you have multiple laws to comply with, which version of sensitive personal data are you sort of complying with? Is it the most restrictive? Are you going with sort of the through line on all of them? And that's something that companies just have to deal with. And then we're seeing some major jurisdictions doing a lot of interesting things. China's been a big one, and the intersection between their personal information protection law and their cybersecurity and data security laws, as well as India, which has toyed with the idea of putting non-personal data into their data protection law as well, which would create some very interesting restrictions. On the risk and efficiency thing, it's the localization piece. I think I was reading the statistics on this. About 75% of the laws that we have globally on privacy have some sort of a restriction on where you need to localize data. Either it must stay there, or there are certain things that you must do in order to move it. So that is creating a lot of, I think, upheaval for companies that are used to having very global structures. And then just briefly, I will mention the end of the third-party cookie, which is taking away one source that people used to use to, or will be taking away that source of deriving information. So now there is this sort of push to retain all this first-party data, and people want to have these huge data pools internally because they're using them or will be using them in the absence of the third-party cookie information to derive their own analytics for things like marketing. But at the same time, that's in tension against the data protection laws, which are saying you need to get rid of everything as soon as you're not using it. So trying to negotiate those two obligations, or the sort of commercial use of data versus the obligation to get rid of data, I think it's an ongoing issue. Sorry, long answer.
Good answer. All right, George.
Yeah, there's lots to cover from a UK-EU perspective, as well as anybody that follows the privacy changes or proposed changes, certainly in the UK, will know. In terms of what's driving the change in the UK, I think the short answer is UK politics, or at least the current government is attempting to drive that change, seemingly, though, with EU adequacy concerns, adequacy status concerns, reining back the major proposals that have been intended to be implemented in recent times, and I'll explain what I mean by that now. So the key change in the UK is that we seem to be, and we've mentioned the GDPR already, unsurprisingly for this topic, but we seem to be edging ever closer to a move away from the GDPR in the UK. Just as recently as July, a new bill was announced into UK Parliament, that bill being the Data Protection and Digital Information Bill, which was originally intended, it seems, to be that vehicle for the move away from the GDPR in the UK. The reality, though, doesn't quite sit with the intention in that regard. The reality is that the bill, once it finally did get announced, did not comprise the standalone new piece of legislation that I think everybody was expecting. It was effectively a red line or track changes version of the UK GDPR. And the bigger news in terms of a reality check is that bill seems to have been scrapped as recently, as quickly as it was introduced. So September was the intended date by which UK Parliament would have the second listen or the second approval of that bill. That got delayed, and to all intents and purposes, it seems as though the bill has been scrapped altogether. That would probably suggest that it doesn't warrant much time on this panel, but there were two key proposals within that bill that I do think are worthy of mention, just in case they do come back to life. And they are effectively the widening of the data protection regulator in the UK, the Information Commissioner's Office, or the ICO, their power to be able to commission independent forensic expert reports on the one hand, but also the power to compel interviews, seemingly, although there was very little guidance around this, seemingly for those companies that the ICO considers not to have responded to a ransomware attack or another cyber incident in a way that they would hope that they would. So we'll have to see if that comes back into play. But as I say, July the bill was announced, September it seems to have been scrapped. By October, it's been a busy old few weeks and months in the UK. The UK government, at the UK Government Party Conference, the Digital and Culture Secretary used that platform as an opportunity to effectively reinstate what we all thought was going to be the case, which is that there will, in no uncertain terms, be a move away from the GDPR in the UK. Interestingly, there was no mention of the bill that I just talked to you about whatsoever, which is shocking, frankly, given it had only been announced in the few weeks before. But instead, a sort of general intention to remove the so-called red tape for SMEs in particular. Again, no real mention of exactly how they're going to do that, nothing in writing at this point, but a general intention to sort of take the best bits from some of the privacy legislation around the world, with Canada and New Zealand being mentioned in particular. I'm conscious that I'm hogging the mic. I was going to talk about the EU-US executive order, but perhaps I can come back to that. If
We can tackle that at the end,
Yeah,
because it's super fun.
That minor detail.
Yeah, quite.
Yeah. Well, okay. Well, let's put a pin on that, because I think that's a great topic to come back to. But for now, Karen, what do you see as driving?
Yeah, these are all really nice and fancy laws and regulations that are being rolled out. Globally speaking, it's a great place to be right now. But we've been facing the internet, big tech developments and digitization, geopolitical tensions. But let me just set the tone. Don't forget where we came from. The U.S. intelligence was warning us for years that the cybersecurity and privacy warning lights were blinking red. How many of you remember that? Okay, well, that's a bad sign. That's why we're here today talking about these laws and regulations. The FBI director, Chris Wray, compared ransomware attacks to 9/11. I don't know if you remember that. That's a pretty scary statement. And then we have Energy Secretary Granholm, who confirmed a while ago that these nation states, these attackers, can get into our electric grid. They have been in there. I don't know if any of you have read the book by Ted Koppel, Lights Out. If you have, the gentleman is saying yes. I don't know if you remember when he asked the defense director whether or not they had a plan to respond to incidences. And I'm talking about cybersecurity because when you have an attack, you lose all of this sensitive information. You lose privacy. So it does create harm to the consumer, to the enterprises. But when the defense secretary was asked, do you have a plan in place, he literally looked at the shelves and looked at the black binders and said, it's up there somewhere. That wasn't too long ago. And now we have the geopolitical tensions between Ukraine and Russia, the attacks that are being perpetrated against against the United States, against other allies. The whole name cyber warfare has changed. Someone the other day was talking to me about troops coming in if there's a missile shot, and I looked at them. I said, we don't have troops anymore. We're looking at cyber warfare. So despite the fact that these lights were blinking red, we still saw major cyber breaches, consumer information being lost, operations being shut down, and critical infrastructure being attacked. The response efforts were pathetic. I will tell you, they have been absolutely pathetic. There's been lack of transparency in them, deceptive reporting practices, failure to investigate and notify, assuming that notification was required. And all of this has been causing harm to consumers and enterprises over a period of time. Maybe there was a reason why they didn't act appropriately. It's not as though they haven't had direction. Maybe they didn't have the budget. Maybe they didn't have cybersecurity insurance, or maybe they just had poor leadership. So in an effort to enhance and standardize our privacy and security standards, we now see all these fancy laws and regulations fully needed being rolled out. We don't have a federal privacy law yet. I'm hoping we get it. But we have a lot of state and federal laws and regulations that are being rolled out en masse. It's almost hard to stay up with them. Someone talks about a 72-hour notification here. The SEC is talking about 4 days over here. It gets very complicated, and that's why we'll just touch upon why it's so important to be prepared. So I think the landscape is going to be robust. I'm glad we're here. There's a reason why we're here. It took us a long time to get here, and now we have to do something about it.
Well, I'm glad you're here too, Karen.
Thanks, Alex.
But to draw out some of those themes that we were talking about, I think a couple of things to highlight are that this is a very international issue. It's a very cross-border issue because the data travels across borders. And that means we're reacting to different legal regimes as we go to the different places. But the other theme here is that it used to be a privacy law or a data protection law, which was just about personal information. But now we're seeing we have to think about data as a whole and the security controls involved as well. And part of the risk of right now is that everybody is churning all of that up to see how we're going to move that forward. But so anyway, I said I wouldn't stay on my soapbox, and I got back up on it. So sorry about that. But so let's zoom in from that international issues perspective to some specific jurisdictions, and starting with the U.S. And we'll do Nicole and Karen one more time. So what do you see as the big issues in the U.S.?
So I think one of the biggest issues right now in the U.S. is whether or not we are going to manage to pass a federal law. I believe we're still the only. Well, following the Chinese law, I believe now the U.S. is left as the only major sort of developed nation that does not have a federal privacy law. So there was one that was introduced earlier this year that has made it quite a ways. It's the American Data Privacy and Protection Act. It's interesting in that it's bipartisan. It's also interesting because I think, as Karen was mentioning, right now we have 50 states with 50 different notification laws, and the federal law doesn't touch those. They are all explicitly excluded. So it doesn't really help from that perspective. It doesn't centralize any of that. So that may be a problem. The two key pieces of the law that have really been getting a lot of discussion are the preemption issue. What will get preempted, what will not get preempted. California in particular, and also because it has such a huge sort of voting bloc within the U.S. House, has been a big holdup on that piece. And then the other piece of it is whether or not there will be a private right of action for individuals to be able to themselves bring lawsuits for specific privacy rights violations. So those are kind of the two big pieces. Of course, we just had a midterm election in the U.S., so that also is sort of creating complexity with this. I think there was some sense at the end of the summer that if they didn't get it passed, that it likely would not happen. It is this particular bill is bipartisan, so it's possible that it could still happen. As of, I believe, about 15 hours ago, we now have a Republican House and a Democratic Senate. So there is going to need to have anything happen on the federal privacy front right now. It is going to have to happen in some sort of bipartisan way, which, I mean, maybe good, maybe bad. It's a little bit confusing, and I was actually trying to find sort of where people were leaning on whether this particular bill might actually move forward right now in the sort of lame duck period that we're headed into with the U.S. government, and people are really mixed. Some people think that those people who've now been voted out might be more willing to compromise and just get this through before they're out, and others are like, no, nothing's going to happen, because realistically, with a sort of Republican House and Democratic Senate, there's going to be bigger issues that they're going to have to figure out ways to compromise on, and that privacy is going to fall by the wayside. Which brings us to state laws. Did you want to add anything on privacy, the federal privacy, before I move to state privacy?
No, go ahead.
Okay. So then, because of that, we have all these state laws right now. Started with California. That was a sort of 2018 law that got passed. In the U.S., we've seen, so I looked up these stats too for you all. So in 2018, there were 2 privacy bills introduced in the U.S. states. This year, 2020, there have been 59. They've not all passed, clearly, but we do have 5 new privacy laws coming into effect in the U.S. next year. So we have the new Virginia law, Virginia privacy law, that's coming on January 1, along with the amendments to the existing California law, so the CPRA, the California Privacy Rights Act. Those amendments all come in on January 1. Then we have Colorado and Connecticut, July 1st, and then December 31st, Utah. So we will have all of those coming into effect over the course of the next 5 months. Plus, if we see things at the same rate as they were this year, we could potentially see another chunk of those. From the sort of cyber side of things, one of the pieces that's new in the CPRA for California that's kind of interesting is that it broadens that private right of action that has already been in the CCPA, but now it includes additional pieces, primarily that if you have a breach that affects an email address plus the information needed to access the account, so either the password security question, that now falls under the private right of action in California, which means that individuals can bring claims if that's part of a breach. And it used to just be that it was mostly like the financial and health information that was involved in that piece, but this could open up quite a bit for the plaintiff's bar in California. So there's that. And then in terms of states to watch, I think, I don't know, I'll give you my top 5 that I think are important to watch based on activity in the past few years. And I think it's probably Florida, Massachusetts, which came very close this year to passing a law very similar to Connecticut's, and then New Jersey, New York also. I have a feeling we'll see the Northeast kind of, it'll be interesting to see whether they trend further toward Europe or further toward California. But I have a feeling the Northeast is going to get online with stuff. And then Washington State is another one that has had quite a bit of movement recently and hasn't actually managed to pass anything. I think one other thing that's worth noting is that we've recently had an addition as well to the New York licensing so as a licensed attorney in New York, we have to do our continuing learning all the time. So we recently had an addition where all attorneys now have to do 1 hour of a class that's dedicated to privacy, cybersecurity, and data protection every 2 years to be re-licensed. So that has now been added in because they feel like it's that important, I guess, for attorneys to understand.
1 hour.
Yeah, I know, a whole 1 hour.
For New York attorneys.
Yeah, it's 1 out of 20.
Oh, boy. I tell you what, I want to be in that first class that's taught on ethics and everything else. Actually, I did have someone call me from an insurance carrier asking if I would give a CLE to their New York attorneys in-house. So something that everyone in this room and up on this panel could certainly do. But we never see that look on everyone's face change when we educate people on cybersecurity and privacy. You know, it's interesting, when we planned this panel, we all came up with topics that we thought would be very interesting to you all, and obviously you know what George is going to be focusing on. But Nicole took the U.S. privacy laws, and so I thought maybe I would run through, and it can't be run through quickly, but I will just comment upon the New York Department of Financial Services regs and let you know where we are at this point. This darn thing changes so quickly. It's you know, you want to tell them to hurry up and get done with it so we can actually see whether or not it's going to be enforced. So they enacted their regs initially in 2017. If you don't know, they have the supervisory power over banks, financial services, insurance companies. That's a short list. They have certainly a longer list for you to refer to. But in 2017, they enacted regs. It covered tech, it covered controls, it covered response in a more general form with regard to responding within 72 hours. Then in July of 2022, they came up with amendments to the original regulations. And again, it covered a new Class A, defined what that new Class A was. It talked about additional techs and controls, which I thought was interesting because now they're focusing on CISOs. They're talking about executives. They're talking about boards. They're talking about accountability. And then it also added to the July 2022 regs additional requirements for all the covered entities. What I want to call your attention to, because I think it's really important for those individuals who are responsible for privacy, cybersecurity, incident response for their organizations, or even for insurance carriers, quite frankly, you have people working for you. They are holding on to very sensitive information that you have shared with them. So I know that insurance companies vet attorneys because I've filled out those questionnaires, but I'm wondering whether or not we should start vetting you all. What do you think? Let's take a vote. No, okay, no one's interested in that. Okay, so with regard to notification, just keep in mind these notification requirements. Pursuant to the recent November changes, and they have not been enacted yet, they're still out for comment. Notification and reporting keeps a notification of an unauthorized access to a privileged account or deployment of ransomware within a material part of the company's information systems. Do you know what they might be? Are they going to know what they might be? If there's an incident and they have to respond, who's going to be sitting in the room while you're trying to contain and eradicate an incident to find out whether or not there's been a material part of your information system has been impacted, so you can notify within 72 hours the commission and others. Notify the NYDFS within 24 hours of making a ransom payment in response to a cybersecurity event. What are you going to notify them about? You all have been involved in incident response, most of you have, and we know that within the first 24 hours, you're still trying to get on a scoping call with your forensics and your client. So what are you going to notify if you have to make a payment within that 24 period of time? You know how special the attorney-client privilege is. You know that we try to be careful about what we share and when we share it. And then finally, if you do make an extortion payment, you have to, within 30 days of the ransom payment, prepare a report to them explaining why the payment was necessary, alternatives that were considered, and sanctions due diligence that was conducted before you pay it. Are you ready to provide these types or this type of information within those short period of time? In November, they added a final amendment, and they added third-party service provider who suffers a cybersecurity event. If you have one of those that you're doing business with, within 2 hours from the time that you were notified that that third party suffered an incident, you have to notify them. Who's making up these laws and regulations? That's what I want to know. But it just emphasizes the importance of vetting your providers, having an instant response plan and team in place, talking about when you're preparing what is a material part of our company's information system. You better know what that is, or you won't be able to notify and report in a timely fashion. There have been a couple of enforcement actions where people have notified but felt they did not need to notify the Department of Financial Services because it didn't fall within their reporting requirements, and they got slapped with fines. If you're going to report to someone, play it safe and report to the Department of Financial Services if you feel comfortable doing that. So you might want to take a look at some of those actions. So that's it in a very short period of time.
Thank you. Okay, so we're going to jump across the pond from over there to over there, and you're up next, George.
Yeah, so from a UK perspective, again, I mentioned that there's been a real change in the privacy legislation landscape, or at least a proposed change. And so too has there been a real shift in the regulatory landscape in the UK. So the shift that I've certainly noticed, and our team in the UK have noticed, is a shift away from education, typically in the form of guidance. So GDPR's been implemented now. You know, this is a guidance that you can use to then make sure that you are compliant. Away from that slightly more lenient approach to education, increasingly in the form of enforcement. And I think that general shift in the regulatory landscape in the UK is true of lots of the industry-specific regulators that are being more probing than ever with our clients post-breach, in terms of perhaps challenging the shield of privilege, legal privilege, to a forensics report, lots more investigative questions as to how this all happened, why you weren't able to protect client data and otherwise. But none more so shock than the ICO in terms of the regulators that are upping their investigative powers. And the Information Commissioner in the UK is still relatively new, coming up to the first anniversary in place. And coming up to that anniversary, it's very, very clear that there is much starker wording within what guidance is being issued. So, for example, partnering up with the Law Society in the UK, telling people like me not to encourage their clients to pay ransoms, being issued by the Law Society in the UK, but also enforcement and monetary fines. And there's one fine in particular that I just thought I'd spend a minute talking about in the UK. It's not necessarily the biggest fine that we've seen or that you'll ever hear of. It was a fine imposed on a construction company called Interserve of the equivalent of around $5 million US dollars. So small change really when we talk about some of the bigger fines within the EU and within the US as well. But really important points coming out of that I think probably have wider global application as well. So just really quick background. Ransomware attack on the construction company arising from a phishing attack. Access to over 100,000 customers, in fairness, very sensitive personal data. Unclear whether that's access in the sort of true form or theoretical access, as we always grapple with incidents like this. Question mark as well, certainly from an external view, as to whether actually there was any exfiltration of that personal data. And ultimately, they did get the vendors that you'd expect to see on the incident response involved with good engagement with the ICO. So far, sounds so good, or at least seems as though it's fairly standard response to a ransomware attack. Now, the problem came in that the antivirus tool, and it was interesting hearing some of the security threat discussion earlier around the difference between use of antivirus tooling and a specialist EDR tool, which I won't pretend I know all of the technical differences around. But the antivirus tooling that was used by this company did pick up the malware in the first instance and said to the company effectively, look, we've got a problem here, but don't worry, we've detected it and we've removed any of the threat. The problem that this company in question had is that they didn't then do the sort of human cross-validation in terms of checking that the antivirus tooling had done what it was supposed to have done. And that, in the ICO's eyes, sort of led to effectively a catalogue of errors from that point in terms of not picking up on the incident properly, not moving fast enough, lots of criticism for not following their own policies, never mind industry standard in terms of the way that they responded to the incident. And so really the key takeaways that I wanted to flag for this discussion in terms of the outcome of that penalty notice, as I say, not the biggest fine, but the important points are that from a UK perspective, the ICO has been very clear that the size of the company meant that the company in question was held to much higher standards than perhaps a smaller company might have done. And I think that's important, again, from a UK perspective, because it sits with what I mentioned the Digital and Culture Secretary in the UK had said around focusing on moving away from GDPR, specifically with smaller businesses in mind. So perhaps from a UK perspective, and maybe other jurisdictions will follow, a carving out of the need to comply with legislation, or at least the extent to which there'll be enforcement action for smaller businesses that might not have the same resources. The other point, the other key takeaway was that one of the aggravating factors as far as the ICO was concerned when it came to calculating the monetary fine was that the company's failure to not follow previous guidance from the ICO, presumably at the point at which they closed their file following notifications of more innocuous data breaches that company might have had in years gone by, that failure to follow the ICO guidance at that point was deemed an aggravating factor that caused the calculation of the fine to only go upwards. So we're now advising our clients as a matter of course to make sure that almost like a tracking claims history under an insurance policy, that the ICO can't look to previous notifications under the policy to try and suggest that they've done anything wrong this time around in terms of not following guidance. And so the final point is that at the same time as issuing that fine, the Information Commissioner was extremely clear that any company that doesn't treat this new fine, doesn't learn from the sort of criticisms that were flagged in that notice, if companies in the UK aren't learning from that, then they can, in no uncertain terms, expect more fines to be issued. So I think we're going to see a huge spike in enforcement action in the UK and more generally, I suspect, in the EU.
Thank you, everybody. So we said at the beginning that we were not going to have enough time to cover all the issues that we would want to cover, and we are keeping our promise on that. So this will essentially be the last prompt, and so I'm going to try to cobble some things together here, because we brainstormed a lot of potential issues to get into, directors and officers issues, intersecting laws like the new European Digital Services Act, children's codes. So to give a very general prompt, and we'll go down the line, George, Nicole, and you'll get the last word, Karen. What's something that we haven't talked about yet that you would just love to bring up to our folks here?
Yeah, thank you. Yeah, you mentioned the Children's Code, and there is a Children's Code in the UK called the Age Appropriate Design Code, which I think is going to generate a huge amount of attention in the next few months and years. But that came into play probably about a year ago now, so I won't spend too much time focusing on that, as I suspect we might from the US perspective. But one area that I thought was worthy of mention from a UK perspective is yet another bill. It was a very busy month in the UK in October because another bill was announced. This one being called the Economic Crime and Corporate Transparency Bill, which was born out of earlier legislation this year, geared really around sanctions arising from the Ukraine-Russia incident. You might be wondering, what on earth has that got to do with data privacy? And I think lots of people would be surprised back home hearing me raise that in the context of this discussion. But there were some sort of hidden gems, as far as I was concerned, as to possible areas that might become more prevalent from a data privacy perspective if it comes into force, as I suspect it might well. And those are two main areas, really. One is enhanced powers for UK law enforcement to seize and recover suspected criminal crypto assets, which is naturally going to be of importance for companies in the UK suffering from ransomware attacks and potentially paying ransoms, or business email compromises where payments are diverted or otherwise. So that was one point, and the other, and again slightly more subtle, but is the proposed disapplication of civil liabilities for breaches of confidentiality when companies share data with law enforcement intended to combat that economic crime. So again, two really subtle points that don't sort of fit perfectly into the mold of data privacy legislation changes, but certainly things to watch from a UK perspective.
Great stuff. Thank you. Nicole.
Right. I just wanted, so one of the things that was sort of on my list to talk about that I think is still quite interesting is a recent decision that we saw from the FTC related to a company called Drizzly that had to do, is sort of a continuation of a trend that we've seen recently, where after data breaches, we are seeing regulatory decisions to force companies to get rid of data. And the three things that came out of the Drizzly decision from the FTC were that they had to destroy any unnecessary data that they were not using, and that was basically defined as any data that they were not specifically using for providing the services that that company was providing to its customers, which in this case is an alcohol delivery thing, in case you guys aren't familiar with Drizzly. In addition to that, they had to document that deletion of their data and report it on a regular basis to the FTC, which is another piece of it that's kind of interesting. They also put restrictions on their ability to collect future data, and that is also tied into what the FTC is requiring in a retention schedule. And then the third part of this decision was that it actually was binding on the CEO specifically, who had failed over the course of 2 years to respond to red flags in their security risk reports. And so there are specific data security requirements that the FTC is now putting in place. And they're doing this within their sort of consumer protection, I guess, their regulatory consumer protection piece of action they can do, because the FTC itself doesn't actually have a whole lot to do with privacy specifically, because we don't have the federal privacy law. So we are seeing them move toward doing more in the U.S. that is in the sort of privacy-ish space, I guess, privacy-adjacent space of that. And we've also seen it recently in New York, where we had, I think it was over the summer, there was another fine that came out. It was part of a New York Shield Act follow-up, where a company was told that they had to get rid of stuff that they were holding in email, that they could save it, but that it had to be saved in a secure format. And it was, I think, it was 6 years, and the AG basically said it's ridiculous that you're keeping things for 6 years in email and other non-secured formats. So I think that is a space where we're seeing a lot of movement toward at least consolidating what you're keeping into secure formats, even if you're trying to keep more data and then also potentially being told that you have to get rid of it.
Yeah, I just wanted to make a comment about that Drizzly case and the CEO being personally responsible and liable for what happened, but also the requirements that they put in place for him. I mean, I don't know how he's going to look for another job, but his next job is going to be based upon the fact that it doesn't meet the requirements of that order that they put in place for him. So let me just tell you what he has to do. For 10 years following the final order, he must implement in a comprehensive information security program at any organization that collects, uses, stores, or discloses personal information of 25,000 or more consumers where he is either a majority owner or a CEO or other senior officer. To satisfy the information security program requirements, he must ensure the following. And then there's a laundry list of things that he has to do. Well, he better not go with an organization that has a bad information security program in place, because he's going to start from way behind and expose himself to further enforcement punishment. So it really was a bizarre ruling in that case. I expect others to follow suit, and then you all obviously know about our friend, the CISO over at Uber, who I think just filed an appeal of his case. We'll see what happens. He blamed it on I think the attorney who handled the incident, and the in-house attorney blamed him for not reporting it. They're talking about a chilling effect that's being placed on CISOs because of the outcome in the Uber case. These cases are going to get more and more interesting. The one item that I just wanted to focus on very briefly, again, they're just proposals, but there are some very disturbing notification requirements in the new SEC proposed cybersecurity regulations that just came out. I did a webinar with a forensic vendor on the proposed SEC cybersecurity regs. It's out there publicly. If you're interested in it, there's more detail. There was a compliance officer on the webinar with us. But just a couple of things. Again, they're trying to enhance and standardize incident response reporting, technology controls in place in public companies and for registered investment advisors and funds. With regard to public companies, here's the notification requirement. Again, how do you prepare for this? If you have a public company that you're representing, how are you going to get them prepared for this? The notification requirement there is basically 4 days. And they've indicated that any cybersecurity incident within 4 business days of the company's determination that the incident is material. Okay, so what is a material incident? What type of attack are you looking at? When did it take place? When did you reach the determination that there's been a material incident? Once you make that determination, you have to report it within 4 days. And then they give you a laundry list of what you need to put in your report. Incident response attorneys must be going crazy because we don't like to disclose these things up front. And the reason is there's data breach litigation. The plaintiff's attorney is going to go right there to find out about what the incident was all about. What did you do about it? Why weren't you prepared? Here are some of the things that go in the report. When the incident was discovered and whether it is ongoing, a brief description of the nature and scope of the incident, whether any data was stolen, altered, accessed, or used for any other unauthorized purpose, the effect of the incident on the registrant's operations, and whether the registrant has remediated or is currently remediating the incident. That has to go in the report within 4 days of your determination that you suffered a material incident. Okay? Obviously, it's a lot more complicated than that or complex than that. There's also a provision for notification for registered investment advisors and funds. I'm sorry to say that the period of time is not any longer. For them, once a determination has been made that there's been a significant advisor cybersecurity incident, you have to report it within 48 hours. Okay, so what is a significant advisor cybersecurity incident? You're going to have to use your judgment based upon the incident that you're facing. There are 10 examples, I think, given in the proposed regulations, but they define it as quickly, significantly disrupts, degrades advisors' ability to maintain critical operations, leads to unauthorized access, use of advisors' fund information, where unauthorized access or use of the information is involved and causes substantial harm to the advisor, client, investor in a private fund. Again, you have to provide a collateral report, confidential, they claim. How do you make it confidential? You can try promptly, no more than 48 hours after making your determination, and having a reasonable basis to conclude that that occurred. So a lot of uphill battles there. I would imagine there's going to be a lot of interpretation, lawsuits, you name it. but we're talking about public companies, and you see that those who have suffered incidences and lost sensitive private information have in some cases caused the value of the company to go down the tubes, investors losing their money and their shares. Violet?
While you're on the SEC, I had a question about the materiality. When you talk about that and you tie it, it's normally been tied to the stock price, but there's been a lot of speculation around these SEC proposed rules that it's a lot grayer than that, and that it goes to things like business interruption, operational impact, reputational harm. What are you guys hearing about that impact and how that might be changing that definition of what we know as a harm or incident?
We always say put yourself in a defensible position when you respond to any incident. Obviously, you're going to discuss materiality when you start that incident response planning, the plan, the team. When you sit down, you talk with the key stakeholders at the organization. Hey, here's the requirement. Materiality is the trigger. What are we seeing out there? What trends are we seeing out there? What do we consider material? I would take a very conservative approach and consider almost everything material and make a judgment call on when to report and what to report, but I would follow it very, very closely.
And follow-up question, how do those overlap with CERCIA? So the critical infrastructure that could also be a public entity, how are those rules going to overlap?
But again, I think I mentioned very early on in the program, there's so many different timelines, the 48 hours, the 72 hours, the 24 hours, to report a payment. Again, I think it's going to boil down to your incident response planning, understanding who you are, what industry are you in, what information are you protecting, what are your obligations based upon that information if an incident should occur, and rolling out the appropriate notification, legally speaking, and in a regulatory sense.
Well, we're out of time, but our panelists have said that they're happy to have more questions in the break, but we'll release everybody else. Yeah. I'm breathless just listening to this panel, so thank you very much. Please join me in thanking our panelists.
Thank you all.
Thank you.